The broadcast is now starting. All attendees are in listen-only mode.
Good morning, and thank you for joining today's webinar hosted by NJ Carr, entitled Potential Massive Liability Under New Jersey's New Equal Pay Act, What All Dealers Must Know. Your presenters today are Dina Mastiglione, Esquire of Genova Burns, and Anthony Anastasio, NJ Carr's Director of Legal and Regulatory Affairs. The Diane B. Allen Equal Pay Act passed earlier this year and took effect on July 1st, just a month ago. Given the potential for massive potential liability for all employers, including dealers, NJ Carr wanted to host this important and informative webinar. Dina and Anthony will address various issues, including who is covered by the new law, what is covered, exceptions to the new law, prohibitions under the new law, and potential damages a plaintiff could receive, in addition to other issues. Before we begin, I just have a few housekeeping details. The majority of your screen will show today's presentation. On the right-hand side of your screen is a control panel with an audio tab and a question tab. If you choose to dial into the webinar with a telephone rather than listening through your computer, the dial-in number, access code, and audio ID are under the audio tab of the control panel. During the presentation, all participants will be muted. If you have a question, please submit it in the question tab. I will be moderating, and I'll be monitoring all the questions. We will address all questions at the end of the webinar. Please try to keep your questions to general issues and not specific to your dealership. We could always follow up individually afterwards. So now I'd like to turn things over to Anthony and Dina for today's webinar.
Thanks, Brian. We wanted to put this together because this is a huge issue for New Jersey dealers and businesses in general, and there's a lot of compliance that's required in order to ensure that you're not sued and not exposed to liability. We have asked the law firm of Genova Burns to assist us with this webinar, and they've been excellent in their materials that they put together, and I'm very happy to introduce Dina Mastiglione, who will be presenting the webinar today. So thank you, Dina.
Thanks, Anthony. Thank you, Brian. Good morning, everyone. This morning we're going to talk about the Diane B. Allen Equal Pay Act and what the repercussions are for your dealerships. This new law has had everyone really kind of scurrying since it was first introduced only in March of this year. The New Jersey State Legislature passed the bill as an act modifying the New Jersey law against discrimination. And you can see how quickly the bill was fast-tracked since it's been signed and has gone into effect effective July 1st. So that's why we wanted to do this seminar here on August 1st to kind of get everyone to start thinking about what do we need to do to get into compliance with the act before we get audited. So just as in terms of background, really kind of what incentivized the state legislature to pass this law was the wage gap by state, and you can see on the slide before you basically what the statistics are for what a woman makes for every dollar a man makes across the country. And surely New Jersey is not the only state to have passed equal pay legislation. New York has one pending, but Massachusetts, Texas, California, this is sweeping the country. But what we want to focus here today is on the Diane B. Allen Equal Pay Act. Named after former Republican Senator Diane B. Allen, she served in the New Jersey State Senate from 1998 to 2018. She herself was a victim of bias and was part of the original negotiations of the bill under former Governor Chris Christie. She had left her broadcasting job after suing her company alleging gender and age discrimination with the U.S. Equal Employment Opportunity Commission. So the purpose of the Diane B. Allen Equal Pay Act is to combat pay discrepancies. Oh, I apologize for the background noise there. I'm in my office in Newark today. So I have to combat police and fire, so I'm sorry about that. The purpose is to combat pay discrepancies based not just on sex, meaning gender, but all protected categories listed in the New Jersey law against discrimination. And you have to understand that many people refer to this act as it really is geared towards making women having equal pay as men, but that's not necessarily true. It applies to all protected categories under the New Jersey law against discrimination, which I'll talk about in a moment. All employers, regardless of size, are required to comply with the new equal pay law here in New Jersey. So regardless if an employer has 1 employee, 50, 100, 1,000, it does not matter. The law applies to all businesses operating in the state of New Jersey. The effective date, as we indicated, it was July 1st of 2018. And what the law provides is that it is unlawful to pay or provide compensation, including benefits, to any employee who is a member of a protected class at a rate less than the rate paid to employees who are not members of the protected class for substantially similar work, viewing skill, effort, and responsibility, unless, which we're going to go over, the exceptions. And what I've done here is highlighted, right, the terms that we're going to discuss this morning. What is compensation? What is included in compensation? What do benefits mean? Also, who is a member of a protected class, and how do I compare when I'm making my analysis by job category, which we'll talk about in a moment? Who's in the protected class and who is not? And what does substantially similar work mean? And what it doesn't mean is equal pay for equal work. Many people think that that's what the law is, but it's not. The phrase in the statute is, quote, substantially similar work. And we're going to talk about what does skill mean, what does effort mean, and what is job responsibility. And I'll give you some examples as we move forward. So what are the protected categories under the New Jersey law against discrimination? Those of you who have attended other New Jersey NJCAR seminars, we've talked about the NJLAD in terms of harassment and discrimination, right? And protecting your dealerships from claims of harassment and discrimination under the New Jersey state law. Well, here it is again, the protected categories: race, age, gender identity and expression, creed, pregnancy, atypical hereditary cellular or blood trait, color, sex meaning gender, military status, national origin, marital status, affectional orientation, nationality, civil union, domestic status, sexual orientation, disability, ancestry, and genetic information. That is a lot of categories. So when we're looking at whether or not we are providing our employees with substantially similar work, right, and equal compensation, we need to be doing an analysis, and we'll talk about how to go about doing that. The categories of our employees. So it's not just male against female, right? It's also age. What are the age ranges of my employees in certain job titles? And are they being paid equally? What about religion? What about sexual orientation, disability, right? Pregnancy status, marital status, familial status. And I have a lot of clients that have been calling me and saying, am I supposed to now ask my employees what their sexual orientation is? What is their marital status? What is their, civil union status, religion, etc.? And we'll go over that. But my answer to that is no. But to the extent we know it, or that we will be, someone will say that we were aware of it, we need to take that into consideration. Surely categories such as gender, age, marital status, that's information that we know, right? We know that by looking at them, by our onboarding documents, when they fill out, their health benefits, if they're designating beneficiaries to certain maybe life insurance policies, 401k plans, right? Whatever it is, certainly we have that basic information about our employees. So those are the categories that we need to be aware of. So it's really important, right? It's not just male versus female. It's not just over 40, under 40. It's all of the protected categories under the New Jersey law against discrimination. So what's considered compensation, right, when we're looking at compliance with the Equal Pay Act? I'll tell you this, the New Jersey law right now, as it's written, doesn't give a definition of compensation. And unfortunately, to date, we don't have written regulations that have been put out by the state to explain what compensation is. So what we're left with here in New Jersey is to look at what is compensation under federal law, because there's also an Equal Pay Act under federal law. So we need to look, and we anticipate that that's what a court will look at. That's what the New Jersey Department of Labor is going to look at, is what do we consider traditional compensation? And it's not just salary. It's just not, right? It's also commissions, bonuses, profit sharing, retirement plans, deferred compensation, paid time off, expense accounts, reimbursement for travel expenses, car and gas allowances, health insurance, life insurance, and any other perks that your employees are receiving. So when we do an analysis of employee A versus employee B, and we're saying, okay, well, they make, $52,000 a year, that's not the only thing that needs to go, in our, Excel spreadsheet when we're doing an analysis. We have to put every single thing that employee is receiving as a benefit of working for our dealerships. And whether or not that's a demo vehicle, like I said, an expense account, reimbursement for gas, obviously the commissions, the bonuses, all of that, any vacation time, sick time, etc., that also needs to be factored in when we're trying to make a compensation analysis for compliance with the Equal Pay Law. Let's also talk about the other issue that we have, and the other really undefined term in the statute. What is considered substantially similar work? So when we're looking at two employees and we're trying to evaluate what do they actually do, we may have written job descriptions, and I know in working with car dealerships for going on 15 years with my clients, many car dealerships I know don't have written job descriptions, but that's something that we may want to consider having, but it's not necessarily limited to that. So as we all know, we may have a written job description for an employee, but the employee is doing tasks that aren't necessarily written on that job description. So what anyone, conducting an equal pay audit is going to be looking at, realistically, what does this employee do on a daily basis? What does he or she do? And what they're going to be looking at, again, is the skill, the effort, and the responsibility for the position. So what's skill? Well, skill includes factors such as experience, training, education, and ability, the ability required to perform the job. And it has to be measured in terms of the performance requirements of the job, not in terms of the skills that the employee may have, right? So the skills not necessary to perform the job are not relevant. It's what the employee is actually doing. So for example, if we have a bookkeeping, right, someone in our back office doing the bookkeeping, that job usually requires accounting skills, but it doesn't necessarily require customer service experience, right? So therefore, a bookkeeping job may not be comparable to a job that relies more heavily on customer service skills, maybe such as the job as an account manager, okay? So we really have to take a look at what they're actually doing, what their exposure to our clients are and our customers, in order to determine what the skill level is. In terms of effort, right, what an auditor or a court is going to look at is the amount of the physical or mental exertion that is required to do the job. And that's going to include also mental fatigue and stress, right? Also, so not just physical exertion, right? The standing, the bending, the lifting, right? Especially in terms of our technicians, right? Our lot attendants, etc. But what is also the amount of physical or mental exertion that the employee needs to do, right, to perform the essential functions of his or her job? So a job that requires someone to stand all day, right, maybe a lot attendant, a jockey, someone that's, detailing, washing, one of the technicians, is certainly not comparable in effort, right, to a job that's more sedentary, right, an office job. On the other hand, the amount of physical exertion that goes into performing maybe janitorial tasks, etc., may be substantially similar. So we got to start thinking also, and I'll talk about this in a minute, job categories, right? How do we classify our employees throughout the dealership? Let's talk about for a minute responsibility. Well, what's responsibility? The degree of discretion or accountability involved. The duties the employee is regularly required to perform. The amount of supervision that's received or exerted, whether the employee supervises others, right? And the degree to which the employee is involved in decision making. So you may have someone that you're calling a supervisor or a manager, but in reality, that supervisor or manager has absolutely no hiring or firing, right, authority. So that's going to be looked at again in terms of responsibility. It includes factors, again, also, can they make policy decisions? Can they determine purchases, investments, others' activities? Minor or occasional differences in responsibilities will not prevent jobs from being comparable. So that's also, very important to look at also. So again, it's skill, effort, and responsibility. And we have to be really honest when we're evaluating jobs. And does this supervisor or manager really have any discretion? Or do they need to get, approval from someone above them to make decisions, right, that they need to make on a daily basis? Also very important, when we're conducting an internal pay audit, when we're comparing wage rates for all employees, it's not limited to your employees who work in your specific dealership, okay? So if I have a dealership and I'm operating in Union County, I have to also compare to what everyone's making in Essex, Bergen, Ocean, okay, at Somerset, etc. So it applies to your employees in all geographic regions, no matter where they are employed, okay? And let me tell you, those of you who have dealerships in New York, you may also have to do a pay comparison and include your New York employees here in New Jersey. And while you all may have your phones on mute, I'm sure I don't hear the gasps, because I've heard it, when we've given this presentation in person, and also dealing with our clients on pay equity audits. But unfortunately, that is the way the law stands now. It is not limited to employees who work in your specific geographic area or even region. And your region extends outside the state of New Jersey. Okay, let's talk about, so the good news, if there is any here. When can an employer differentiate pay? So when can we justify that we have two employees in the same job category making different salaries, right? And receiving different compensation? Well, we may do it only if we are able to demonstrate the following. The differential is made pursuant to a seniority system, which I know we don't really have a lot of dealerships. The differential is made pursuant to a merit system, and we'll talk about the importance now more than ever of performance evaluations, right? actually sitting down with our employees and giving them performance evaluations. We'll talk about that in a minute. The differential is based on a legitimate bona fide factor, such as training, education, experience, quality of work, quantity of work, okay? And we got to document. The factors are not based on and do not perpetuate a differential based on sex or any other protected category under the New Jersey law against discrimination. The factors must be applied reasonably to the differential in compensation. One or more of the factors that I just spoke about must account for the entire wage differential. The factors are job related with respect to the position that we're evaluating. And the factors are based on a legitimate business necessity. Are there alternative business practices that would serve the same purpose without producing the wage differential? And it's a lot. And the only way we're going to survive an audit or we're going to survive a lawsuit is if we're documenting the reasons for our pay differential. I had a client that said, you know, I don't really have employees filling out job applications. I really only have people kind of dropping off applications to my dealership, submitting resumes either through Monster or Career Builder or whatever, you know, internet, service that you're using. And I said, I understand that. I said, but now we really have to more formally, set forth policies and procedures for our onboarding. And even if someone's coming in just with a resume, we really need to have them fill out a job application, which is going to ask them maybe more information than is contained on their actual resume, because that is what is going to help us justify a pay differential. Okay, I had talked about this earlier. Looking at where you operate, again, we have to look at your wage rates in all of your operations or facilities. A question that we get: can salary history justify a current pay disparity? And the answer there is no, it can't. So the law prohibits first public employers and also now private employers is coming, but right now the law is public employers cannot inquire about salary history during the interview process, okay? And can't consider an application's refusal to volunteer compensation history in any employment decision. There is legislation pending here in New Jersey to extend that law to private employers. And it's already the law in New York, New York City, I should say. And I anticipate this law will be signed by the end of the year. So what does that mean if passed? We can't ask anyone on a job interview what their salary history is, how much money they made at a prior employer, okay? So be forewarned that that is going to be an issue. So my suggestion and the suggestions that we've discussed with Anthony and everyone at NJ Carr is ask applicants, what is your salary requirement? What would you like to be paid if we hire you at our dealership? That is a different question than asking, what did you make at your prior dealership? What were your average wages? What were your average commissions, right? We're going to have a problem there. Like I said, though, right now, it's not illegal yet. And of course, once it becomes illegal, we will immediately put out a blast with NJ Carr to notify everyone. So the suggestion is to start getting into compliance, only asking what an applicant's salary requirement is and not salary history. Can an employer restrict discussions about wages amongst their employees? The answer is no. So if we find out that our employees are discussing amongst one another what they're making at work, the law prohibits us from taking adverse action against those employees. It is unlawful for us to take reprisals against any employee from discussing or disclosing to another employee or former employee, a lawyer from who the employee may be seeking legal advice, or any governmental agency information related to employee compensation. So if we have employees discussing salary, commissions, bonuses amongst one another, and management is alerted to that, we are not permitted to take retaliatory action against those employees. What we also cannot do is require our employees, as a condition of employment, to sign waivers or agree not to make these types of requests or disclosures to one another. So, many employers used to have statements in their employee handbooks saying that they're not to discuss salary, history, or compensation amongst one another. That is now illegal, and we're not permitted to do that. Okay. So I talked earlier about pay equity audits and what is that and why do we need to be doing them. Well, certainly, since the law is effective in July, we need to start looking at it. The goals of the audit is obviously to identify potential pay disparities, right, within the job classifications, at your dealership, and within those categories of protected classes under the New Jersey law against discrimination. Determine whether or not our dealership has lawful explanations as to why there are disparities. And if we find out that there are disparities, what are we going to do to try and correct them, right? And also to identify and correct the weaknesses to hopefully ward off claims and be proactive by our employees. And I also wanted to talk about, too, why do we conduct and why do, something that we've discussed with NJ Carr and agree is the best way to go about your initial pay equity audit is why should it be privileged and why should it be conducted with in tandem with legal counsel? Again, why? Because if you have a pay disparity, if you hire legal counsel to review and perform that pay equity audit, that is privileged and confidential. So what the steps that you're taking to correct it, but the discussions with legal counsel and the fact that there are disparities in pay and that you may have issues is all protected and confidential and cannot be disclosed in the event of litigation. So,
Dina, can I just chime in for a minute?
Of course, Anthony, go ahead.
I just want to make sure it's clear to everybody who's participating that, you really can't be penny wise, pound foolish with this, where you attempt to do it in-house, you try to do it on your own, because you're basically just creating an evidence bomb that's going to go off when the first disgruntled employee decides to sue you under this new law. If you do it with an attorney, then you're in the driver's seat with respect to the release of the information. So you can decide whether or not you want to release your findings or not because it's protected. I can't really emphasize the importance of this fact enough. I've received many calls from our members about this who've expressed interest in doing this on their own in-house, and I think it's extremely unwise. I think you really need to have an attorney to guide you through the process and to shield you with the attorney-client privilege. So I just want to emphasize that to all our members on the call who are participating, just how important that fact is. I'll let you get back to it, Dina.
That's fine. Thanks, Anthony.
Dina, if I could just interject for 1 second.
Of course.
I just want to remind people, I am getting a couple of questions. We will be addressing them at the end, so don't think we're ignoring you. I just want to remind people of that. If you have a question, send it in. We'll address them at the end.
Hang in there. We'll definitely do that. No problem.
Yeah.
Thanks, Brian. We'll definitely be doing that. Anthony's point is well taken. The initial audit, and again, the fact gathering, the information that's needed for the audit, that can all be done, by your dealership, to get all that information together. But the privilege is absolutely the most important thing. And then at the end of the audit, if we determine there are no pay discrepancies here, or we've remedied the pay discrepancies, then in the event of litigation, we can have discussions about whether or not we want to waive the privilege, because there can always be waiver of the privilege at the end. But the initial process has to be done and is highly recommended being done with legal counsel, because in the event that there are pay disparities, we need to know that, you need to know that, and we need to address how we're going to fix it. So you establish a protocol to ensure the audit is privileged with the assistance of legal counsel. You treat the process as privileged throughout, meaning any documentation and any data that we're gathering is going to be, flagged and written on the documents prepared at the request of legal counsel, so that they could never be, again, turned over to opposing counsel in the event of litigation, or frankly, in the event of an audit by the Department of Labor. And you maintain a strict, what we call litigation control group. And what does that mean? It means that we only have a few people in the dealership who are on a need-to-know basis about collecting the data, working with legal counsel, so that we can maintain a strict group that is only on a need-to-know basis, right? And then what we also end up doing is we repeat the audit, right? So we do the audit, maybe now, since it's July, right? It's now August. We should be doing the audit now, and then we should be doing the audit at the end of the year, right? Or in early January, to determine, once we've paid out end-of-year bonuses, given raises, etc., that we are on track, right? And that we are still complying with the equal pay law. And like I said, there can always be consideration, and Anthony mentioned it as well, a waiver of the privilege, so that in the end, if we've done the audit, right, and we've determined there are no pay equity issues here, then we waive the privilege, and then we can turn over the audit if we have to have that happen. Also, the audit is important to identify systematic problems and issues that we may be having within our dealerships. Do we have a lack of meaningful standards and guidelines on pay rates, increasing our pay rate, components of compensation? Are we not training our management on how to make those determinations concerning pay rates and pay raises and compensation increases? Are they just saying, well, I liked him, so I'm going to give him a raise, and I don't like her attitude, or I don't like his attitude, and he's 55, and I like his attitude, and he's, quote, young and hungry at age 32, right? These are things that we need to train our managers on. What is management's discretion, right, with making the decisions? Do they have to, making sure our managers have to get approval, right, and sign off from someone above them in order to make final compensation decisions, right? Failing to actually communicate the criteria to our employees so that they know what the basis of our decisions are when we're making compensation decisions, right? And, again, use of favoritism is a big, big issue. And again, we have to train our managers better in having them understand that when making these decisions, they need to understand if we're going to engage in a pay differential and we have employees that are memberships of different protected categories, that we have a legitimate business reason for making the compensation decision that we're making. So in terms of, kind of gathering information, right, for a pay equity audit, what do I need to be looking at? What are the documents that someone's going to be asking me for, right? Whether it's your legal counsel, whether it's the Department of Labor, whether or not, God forbid, it's in litigation. The names of your employees, what is their protected category? And let me just stop here again. Remember, we may obviously not know what their sexual orientation is, right? What their religion is. And I'm not suggesting that we need to go out and ask them. Let us not do that. But to the extent that we know, like I said, age, marital status, familial status, race, they may have self-identified, right? Age, certainly we know. Gender, we know. That has to be put on, that has to be flagged. Primary work location, like I said, primarily where does the employee work? What dealership location? Whether or not they work full-time, part-time, are they a temporary or seasonal worker? Are they exempt from overtime or are they not exempt from overtime? What is their date of hire, right? When did we hire them? Or actually, this should also say rehire. The job title, what is their actual, quote, job title? Job code, grade, band, if you have them. The department or business unit that they work in. What are the job functions and responsibilities? And I talked about that earlier. What does the job description say, which if they have a written job description, and what do they actually do? So that actually should really be kind of two columns if you're thinking about it in terms of an Excel spreadsheet. What does the job description say they do, right? We may have a receptionist that the job description says answers dealership phones, but in actuality, they're also maybe doing some paperwork, maybe they're processing, motor vehicle title work, whatever. They may be doing added responsibilities, right? So we need to be mindful of that. Who is their supervisor? Who do they report to, right? What is the highest level of education of each employee? What are their special licenses or certifications that they may have, right? In terms of the technicians, that's a very important. We want to know what licenses and certifications they have. What is their pay type, hourly, salary, commission, etc.? What's their annualized salary? Are there any shift differentials, their bonus eligibility, their bonuses paid, right, and their total compensation? These are all the things that we need to be looking at so that when we evaluate the job categories and the employees, this is what we'll be looking at, right, in terms of doing it. And like I had said earlier, let me talk about first in terms of looking at the job function, responsibilities, and departments. NJ Carr just put out this, those of you that follow NJ Carr on Twitter yesterday, kudos to Anthony and Brian, because I said, this helps us perfectly. The average number of employees by dealership, in dealerships by department in 2017, service, vehicle and sales, administration and others, parts and accessories, and the body shop. So in terms of evaluating jobs, right, and job departments within dealerships, this is how we should be thinking when we're setting up and we're conducting a pay equity audit, is what are our job categories. And so thanks, Brian and Anthony, and to NJ Carr for kind of giving us these statistics from last year. But in terms of departments, this is what we want to be thinking about. Okay, we're reviewing job descriptions and not job titles. Again, equal pay for substantially similar work. If we don't have job descriptions, maybe we want to create them. If we have them, we want to look at them, we want to revise, and we want to update them. And we also want to consider maybe creating new job titles. And I had this issue come up in another seminar that I gave on equal pay. And I'm not sure, maybe this is a question that may come in from someone on the line. Dina, if I have two receptionists, let's say, and I have a receptionist that's been doing this job for, 5 years, and I have another, maybe young woman, straight out of college who wants to be a receptionist in our dealership, and one is 55 and one is 22, now what do I do? And I said, listen, or maybe it's a bookkeeping job, right, or a job in the back office. I said, maybe we want to think about job titles, senior bookkeeper, senior receptionist, etc., right? Because that will help us differentiate job categories and may help us justify a pay differential. Something to think about is the creation of new job titles within our dealerships. Number 3, again, equal pay for substantially similar work. If not, why not? For those receiving more pay based on seniority, skill, performance, do the increases perpetuate a pay differential based on a protected characteristic? And these are the things that we honestly need to be thinking about. Question for number 4, should salary adjustments be made? And this is a question we get all the time. You are only allowed to adjust salaries upwards, and you can never decrease salaries to correct a pay differential. Cannot do it. So if we determine that we have a pay differential and we say, okay, so what I'm going to do then is decrease my higher paying employee to the same salary as the lower paid employee. That is illegal. We cannot do that. We can only raise up. And again, I'm sure if everyone had their phones on the microphone, I would hear cursing and gasping on the line, because you can't do it. It is 100% illegal. And what we've told clients is that if we're conducting pay equity audits now in the summer, and we find out that we do have a pay differential, we may want to consider fixing those pay differentials in end-of-year bonuses to our employees. And it's the only way that it's going to help us. Because otherwise, remember, decreases never fix an unlawful differential in pay, and it's illegal. Number 5, consider adjusting starting salaries, right? We may want to think about that, right, based on prior experience. That may be something that we want to do. Taking performance evaluations seriously. We need to do it. And I know, like I said, in dealerships, especially with sales consultants, even to extent service advisors, we really don't perform written performance evaluations because we're evaluating them, right, based on sales. But there are intangible factors that lead us to making decisions with respect to pay that don't, obviously include how much they're making in terms of commissions, et cetera, right? How they're interacting with our customers, how they're interacting with their coworkers, right? All of these things can't be found on a spreadsheet. So we really want to think about and document performance evaluations. And I know no one wants to do it, but I think the time has come where we have to change our mindset and start sitting down with our employees and giving them formal performance evaluations so that we can document the reasons for our decisions with respect to pay. Okay, train hiring personnel, like I said, and those of you who have an HR department on the new law. We have to revise our handbooks. Those dealerships that have handbooks, we're going to have to take a look at them, take a look and determine whether or not we have updated anti-discrimination, anti-retaliation, and complaint procedures. And again, policies that we may have had in our handbooks that restrict our employees' ability to speak about their wages in the workplace. If we have prohibitions in our employee handbook that do not allow us, that make it, prohibit our employees from talking about pay in the workplace, that is now illegal, and our employee handbooks need to be updated. Removing salary history questions from job applications. Again, I had said earlier, it's not illegal yet, New Jersey, it's coming, but maybe switch to asking what their salary expectations are. And number 10, if you award bonuses, contemplate having a structured, objective, and award system. I think that's the best way to do it, and to kind of formalize, now your documentation of your pay decisions. We have to do that. Date the decision on pay was made, the names of the decision makers, right, the managers, anyone that was spoken to in terms of who we got feedback from in order to make our determination with respect to pay. What are the pay ranges for the position, if we even have any? What's the basis for any objective factors that we're considering and relying on? What are the subjective factors that we're considering and relying on? And any other basis for the pay decision. And what I have here that's kind of highlighted at the bottom, reliance on external market forces is not a get-out-of-jail-free card. So we can't start arguing the economy, the economy, the economy. Unfortunately, it's not going to get you anywhere. It doesn't matter. So we can't start arguing the dealership's not doing well. The pay differential is what it is, and we're going to have to consider raising people up, changing job categories and descriptions, etc., in order to equalize, okay? When we're hiring people, that may be a consideration, but when we have current employees working for us, if there are external marketing forces, we may have an issue, right? It's not a get out of jail free card. Performance evaluations, again, assess the performance evaluation process. They should be conducted based on objective and subjective factors. And again, managers need to be given concrete examples of good or bad performance evaluations. And I tell people this when we conduct training and seminars with respect to performance evaluations. None of us want to be the bad guy or the bad girl, because we know that maybe giving someone a bad performance review won't lead to a pay increase. So we feel bad about it, but we can no longer feel bad about it. We have to be honest, and we have to be thorough in conducting the performance evaluations, because it's going to save us from a pay equity audit. Just like a performance evaluation saves us if we ever have litigation where an employee accuses us of harassment or discrimination. And we've had many cases where we argue that the employee was a poor performer, and we had to let them go, and the performance reviews come back with a 5 out of 5 performance rating, and it exceeds expectations and it meets expectations, and it becomes a problem and an issue. So we have to really, really think about being honest on the performance evaluations. And I understand our managers, our supervisors, and our dealerships, our goal is to sell cars, our goal is to service cars and make money, but this is just as important, and it's going to save us in the event of an audit or litigation. Again, if we ever determine that we have systematic problems, what do we do? Maybe we consider implementing pay ranges or guidelines, right? Consider implementing written policies for pay increases and communicate with the employees about their eligibility for pay increases and their performance. Okay, prohibitions under the Equal Pay Act. As I said, we have an absolute prohibition against retaliating employees from discussing with current or former employees or their attorneys any information with respect to their salary. If we have an employee who opposes a pay practice or raises objection to a pay practice, we are prohibited from retaliating against them, right? Similar, if we have an employee raising complaints of harassment and discrimination, we can't take retaliatory action against them. Same here. If they share relevant information with their legal counsel, if the Department of Labor asks them to cooperate in an audit, right, we are prohibited from retaliating against them. Even if they file a complaint, they testify, or they assist in any legal proceeding, that is absolutely strictly retaliation, is strictly prohibited. Employers also cannot coerce, intimidate, threaten, or interfere with anyone, right, seeking privileges under the Equal Pay Act. Or we cannot coerce, intimidate, threaten, or interfere with anyone who has aided or encouraged someone else to enjoy the privileges and the protections guaranteed by the Equal Pay Act. And employers cannot require employees to consent to a shortened statute of limitations. So what is the statute of limitations for the Equal Pay Act? Well, hold on to your hats. 6 years. That means an employee has 6 years and can look back 6 years to sue us, to sue our dealerships for a pay differential. They can get 6 years, okay, of the pay differential as damages if they are successful in a lawsuit under the new Equal Pay Act. So many of my clients have asked me, Dina, is the statute retroactive? And I tell them this, it doesn't say if it is or not. Great, right? It doesn't say, but my argument, all the attorneys in the field that I practice in, our take on it is that it is not, but there will always be a lawsuit that's going to test it. But we don't believe that it is retroactive because it doesn't specifically say that it is. But that means in 6 years from now, if I have an employee that discovers a pay differential and they can sue me for the differences in my salary for the past 6 years, and that is a long time, okay? Each pay period in which there is a pay differential restarts my statute of limitations. So with every paycheck that I get, my 6 years starts again if there's a pay differential. Also, since I had said, earlier, about an hour ago, that this law amends the New Jersey law against discrimination. Under the New Jersey law against discrimination, employees are also awarded compensatory damages. What is compensatory damages? Pain and suffering. The pain and the suffering that they have endured due to the pay differential. Punitive damages are available to punish the employer for engaging in wage disparity, okay? So what does that mean in terms of an audit? That means if you do the audit, you find out there's a pay differential and you continue to do it. You continue to keep the pay differential. And if that audit isn't privileged and in litigation it's found out that you knew it, you did the audit, and you never corrected the pay differential, you may be liable for punitive damages. And guess what also? Attorney's fees and costs. So that means if an employee is successful in winning a pay equity lawsuit against your dealership, you have to pay their attorney's fees. Very, very expensive. And that's always a driving factor in these lawsuits. Those of you who have been in a position to having to defend a discrimination or harassment case and have been involved in these cases for months and years, and when you see that attorney bill, the plaintiff, the employee's attorney's bills, your head spins, and it is in 6 figures. So you can see how lucrative these cases are to employees' lawyers. And also, scary, the statute awards treble damages. What does that mean? That means an employee can recover 3 times the amount of the pay differential if the employer is determined by a jury to have engaged in unlawful employment practices. And now you can see why we labeled this seminar the way that NJCAR did. It is scary, it's severe, and it may be one of the most important new laws that have been passed since the New Jersey law against discrimination. And you can see, what will be driving these lawsuits and what has been driving them, currently in other states. Also, if you, companies that win contracts from public agencies, again, this doesn't really apply to the dealerships, but they actually have to proactively provide reports to the Commissioner of Labor and Workforce Development. Might be coming also for our private sector employers that are not awarded contracts from public agencies. It might be coming. So what about litigation? And I've been talking about this throughout. An avalanche of litigation, unfortunately, in the area of pay equity is anticipated. Just like right now, we have to deal with harassment and discrimination lawsuits. We have to deal with lawsuits under the Fair Labor Standards Act, right? We got to deal with FLSA, class actions, etc. This is coming. High-profile lawsuits against technology companies, law firms, pharmaceutical companies, retail chains already have been filed. Collective and class actions, million-dollar settlements, and the Time's Up movement, right, suggests it's coming and more are on the horizon. Just kind of in terms of, what's been going on, female partners at top law firms seeking $100 million for claims of discrimination, equal pay, and retaliation. That's coming out of New York, $3 million settlement. Merck and Company, lawsuits by female sales representatives for $250 million, right? Gender bias suits. Forest Laboratories by sales representatives, cases settling in the millions and millions of dollars. So this is what's happening in other states. This is what's happening, in the federal landscape. And unfortunately, we're all bracing ourselves of what's to come here in New Jersey. So I'd ask anyone if you have any questions or concerns, and Brian can certainly, go through those questions with us, but I'd like to thank everyone for their attention this morning.
Dina, I just want to add one point, and thank you very much. I thought that was very thorough and thoughtful and helpful. Really appreciate it. But one thing I'd like to add about the litigation component, this new law and whatever else the current administration is willing to allow to be signed into law really makes the employee arbitration agreement a critical document to obtain, more so than ever before. And what that is essentially when you onboard an employee, or even your current employees, since they're at will, most of them are at will anyway, you have the ability to demand that as a condition of their employment that they sign an arbitration agreement. And if they sign that agreement and it's enforceable and it's drafted by a lawyer and done right, you can force a lot of these claims into arbitration, which will significantly reduce the litigation costs and a lot of the uncertainty as to the result, because there's no juries in arbitration. So, I mean, a lot of this stuff really just makes that document essential, an essential part of your kind of compliance plan and your defense strategy in dealing with these social justice laws that are popping up now. So I just wanted to add that one point, and if Dina has anything to kind of add to that point, she's welcome to, and then we'll open it up to the questions that were sent in.
Yeah, great. I mean, 100%. I agree with Anthony. And actually, recently I had a client that I was working with to revise and update their employee handbook. And a question I had from them was that in their employee handbook that I was revising, they had an arbitration agreement contained in their employee handbook. And this literally just came up in the past 2 weeks. And I want to caution you, those dealerships that are on the phone with employee handbooks, please make sure that there is no arbitration provision or agreement in that employee handbook. We can, and as Anthony said, we can have separate arbitration agreements, and arbitration agreements are under fire now too in the courts. So we got to make sure they're correctly drafted and signed at the time of hiring. And there are certain specific requirements that have to be in there, but it needs to be a separate standalone document. It cannot be contained in your employee handbook, because what will happen, and Anthony mentioned the phrase at-will employment, right? If you have an arbitration agreement that's contained in your employee handbook, a court will then convert that employee handbook into a contract of employment, and we don't want that. We want to be able to walk into a court and say, no, judge, they signed a separate enforceable employee arbitration agreement that was separate from the handbook, and they are still at will. So I remind you now is the time. Please take a look at your handbooks. Make sure that that's not in there. And as Anthony said, consider now with hiring of your new employees to have them sign employee arbitration agreements. That's not to say that, you're still going to have to hire a lawyer and engage in the arbitration process. But as Anthony said, you'll be dealing with an experienced arbitrator, a retired judge. You won't have to deal with the uncertainty of a jury, which is very helpful, especially depending on what county you're in. That can be very, very much increase your odds and your success of a favorable determination on behalf of the employer in arbitration.
Thanks, Dina. Much appreciated. You want to go to questions, Brian?
Yeah.
All right.
Dina, I'm sure you'll be shocked. There are a lot of questions. What I'll do, if either you or Anthony think any of these questions are too down in the weeds, I will apologize ahead of time to any of the people who are asking them. We could always have Dina or Anthony follow up with you after the fact, because we've been going a little less than an hour. There are a lot of questions here, and I'm sure more will come in as we're answering these. So if either one of you feel that these are too detailed, we can address them after the fact.
Sure.
And I'm going to go in the order that were received. So some of these may be referring back to the early part of your presentation. If a dealer owns more than one dealership in New Jersey, but they're operated as separate entities and have independent federal employer identification numbers, can they have different pay structures than their other entities?
Great question. And I've gotten that question before, and I'm glad that someone brought it up. My position would be yes, but I have to kind of give a fair warning to that. There are many clients that I have that operate separate independent dealerships under separate corporations, right? Corporate names, separate tax ID numbers. However, the decision-making authority is really centralized in 2 or 3 people that deal with the decision-making in every single dealership under the banner, right, of the operator. So you have to be really careful. And this is the same analysis that we do in cases of, harassment and discrimination, where they want to sue, we have employees that want to sue the auto group and not necessarily maybe the Infinity store or the Jaguar store, right, or the Toyota store. And so we always argue they don't work for the auto group, they work for this specific dealership. So my answer is, I would argue, and any legal counsel would argue, this is a separate entity, a separate corporate entity, separate operator, separate tax ID number, and we have to answer to our manufacturer, and there are different rules and regulations with respect to each dealership. And that would be my argument. But you may have an issue is if you have a general manager or a controller of that one dealership who needs to answer to someone else in corporate and who really doesn't have independent decision-making, there may be an issue. So I just want to warn you there. There may be an issue. So it would be a fact-specific, but my inclination, and I'm sure any legal counsel on the defense side will argue, this is a separate dealership, and how can we say that someone working at an Infinity dealership should make the same amount maybe that somebody is making at a Mercedes-Benz dealership or a Jaguar dealership or, a Prius dealership or whatever it is. So my answer to that is yes, I would argue that they're independent dealerships, but I would caution you, and no day like today, make sure that those managers don't have to answer to somebody maybe at your other dealerships when making compensation decisions. Anthony, anything to add to that?
No, I think that's pretty much exactly what I would say.
Yeah.
I mean, common control can lead to some issues despite separate corporate structure. It's really the courts are going to bend over backwards for the plaintiffs in these cases as these laws start to develop in the courts, and I could see them taking a common control test over separate corporate ownership to determine liability.
Yeah, let me just add one other thing. If I have,
Sure.
2 Infinity dealerships, let's say I have one in Somerset County and one in Union County, obviously those are going to be considered the same, right? So we got to look at the manufacturer too. But I agree, common control, the centralization of decision-making authority, that's what's going to be looked at.
Yep.
Okay. You kind of addressed this next question towards the end, but I'll ask it anyway. How does this affect an arbitration agreement that is already in place? Should we have specific verbiage? Should we have specific verbiage to address this or modify it?
Well, the issue is unfortunately, current employees, if you want your current employee to sign a modified or updated employment agreement, there needs to be consideration for that. So, but yes, they should be looked at and updated so that you can have current and updated arbitration agreements in place for your new hires. So absolutely, because there has to be specific language with respect to the employee understanding that they waive rights to a jury, that this agreement applies to all claims that they have in employment, and also you would have to revise and update it to include not only for harassment, discrimination, whistleblowing claims, but also I would add in the new ones, pay equity claims, right? That's got to be put in there, because what the court does is they look at specifically the language of that arbitration agreement, and the number one inquiry they have was, when the employee signed it, did they understand exactly what they were waiving? And the only way to know that is what's written on the paper within the four corners of the document. That's our lawyer expression. Four corners of the document. What is actually written on that piece of paper? So the answer is yes, they need to be revised and updated now after July 1st for all new employees. And with the current employees that we have, it's going to be an argument. It's going to be an argument if you have a catch-all. Does that include the catch-all include, any and all disputes that arise during the course of employment, right? If you have the catch-all, I would argue it applies. But in order to get a current employee to sign a new arbitration agreement, you have to give them consideration. And what that consideration is, I don't know. Let's talk. Call Anthony, and then he'll call me, and then we'll discuss it. But that's tough. Anthony.
Yeah, I mean, it could be as part of a year bonus,
Yep.
raise. I mean, there's all sorts of ways you could structure it where you can kind of give them the carrot to make them go along with it.
Yep.
But, I agree that, you can't just spring it on them, and expect them to sign it without protest if they don't have an arbitration agreement already in place. But given the exposure here, and as I said before, the real, I don't think I said this in this seminar, but I know I've said it in others on this topic, the real beneficiary to this statute is the plaintiff's lawyers. Those are the people who are really going to win with this thing, not the employees. And to keep them at bay, to prevent the shakedown, you really need to have an effective arbitration agreement in place. And that, too, is not something you could just wing. It doesn't lend itself to going on the internet and pulling a form off the internet and slapping it on a piece of paper and having them sign it, because New Jersey is relentless in trying to rip apart arbitration agreements that other states would have no problem enforcing. The courts hate them in New Jersey. So you really need to have a tight, effective agreement if you want to avoid these issues going into courts and being shaken down by the plaintiff's lawyers for millions of dollars.
Okay. Yeah, we saw a lot of questions.
Let's move on.
Do you recommend a written policy that addresses discrimination, specifying everything we've been talking about here, in an effort to show transparency to new hires?
So obviously in the onboarding process, right, we're going to have them sign off on receipt if we have an employee handbook, right? If we do not, we're going to make sure that we do have a policy against harassment and discrimination in the workplace, and against retaliate, and a policy that the workplace is free from retaliation. So the answer is yes. So when we hire new employees, we're going to have to now update our anti-harassment policies and our anti-retaliation policies to include these issues, right? And to have everyone understand that we're obviously, that our pay decisions, our hiring decisions are made without regard to anyone's membership in a protected category, right? So that's our equal employment opportunity statement that's also contained in a handbook. And so this is also why, like I said, I've been working with dealerships for a long time, and I have many clients that don't have a handbook, and I understand it. I obviously understand their business reasons for not having one. Maybe they only have 50 employees. Maybe they have 35 employees. Maybe they have 100, and they don't want to have one. But now more than ever, it is important to document these policies, have it written somewhere so that employees know that we have the policy. And if we're ever challenged, we can say, no, it's in our handbook. It was given to them when they were hired. They signed off on it, and that is our dealership's policy, and they have it. That's yes. So the answer is yes. Yes to that question.
Okay. Hopefully some of these other questions are easier. Would geographic location be considered a legitimate bona fide factor to justify a differential? Difference in living costs due to geography seem to satisfy all the elements. How can a rural New Jersey dealership be expected to pay the same price as a Manhattan dealership?
Oh, I hear the frustration. And I agree with you 100%. Unfortunately, the New Jersey State Legislature doesn't agree with us. And I have to say that we're going to have to come up with another reason. We got to come up with another reason and not And listen, I understand market forces and, you know, and all those other issues. But right now, without the regulations that have come out, and I don't know what they're waiting for down in Trenton, but Anthony, your neighbors with them down there, maybe you can walk over there, take a drive.
Yeah.
But, you know, and tell them we're frustrated and we need to know. But my answer to that is, unfortunately, it is a factor. We have to look at it in terms of determining the pay differentials. And we got to come up with another reason why we're not paying them the same, because the statute as it reads is all locations.
Okay. I'm going to keep barreling through these.
Sure.
If the employer pays 50% of the health insurance, if the employer pays 50% of the health insurance for employees who want insurance, shouldn't the employer pay the same to employees who choose not to get their insurance, or who choose to get their insurance elsewhere?
Dina, I think on this question, you know, ultimately they're providing a benefit that they shouldn't be forced by virtue of somebody not willing to accept that benefit to somehow supplement their decision in that regard financially.
Agreed.
I don't think there's any need. You know, you provide a plan, employer-sponsored plan. You pay half the premium. That's it. Mm-hmm. You shouldn't have to adjust, you know, your pay practices to accommodate people who don't want to participate.
100% agreed.
Are part-time and full-time employees who have the same job considered the same in relation to benefits offered? Heavy sighs on both their parts.
Yeah.
I mean, I think that on this, I mean, if your benefits program, let me make sure I understand the question correctly. I mean, my understanding of this question is, if you have a part-time employee and a full-time employee, and you have a policy that says only full-time employees get health benefits, I don't see in and of itself an issue. I suppose that if, you know, you had a disproportionate amount of part-time employees that were in one protected category and full-time employees that were in another, maybe they can make a claim. But beyond that, I mean, it's similar to the last question. You know, if you have you have a policy with respect to who is entitled to your benefits based on the number of hours they work, I mean, there could be a legitimate business reason for that. But I mean, again, unfortunately, with this new law, now everything is questionable, and I don't want to use the term loosely, but everything's politicized now in the context of workplace, you know, management decisions, as far as, you know, well, you did it because I'm this or I'm that. So I can't say in and of itself this is a problem, but you know, there could be an issue lurking depending on, you know, the particular employer.
Yeah, I agree 100% with Anthony. I don't think this would be an issue at all, right? But remember, one of the factors that may be looked at, and it's very unfortunate and, you know, can be somewhat preposterous, is does it perpetuate, right, a differential? So like Anthony said, if you have more members of a protected category that work for you part-time than you do working for you for full-time. But I think that's a stretch. I think that's a huge stretch, and I'm not sure a court, I'm not going to talk to the Department of Labor, because I think that's something maybe they're going to look at, but I just don't think that that's going to be an issue. I think they can be considered separate.
Okay. Does this new law apply to employees who are members of collective bargaining agreements?
Yes, everyone.
Oh, short answer. Good. Okay. Easy one.
We're not known for short answers, Dina.
Is the pay equity audit initial and follow-up required or a recommendation?
What?
It's a strong recommendation.
It's a strong recommendation. Compliance with the new law is required. So however you go about complying with the new law, and frankly, I don't see how you can comply with the new law unless you conduct an audit, right? That's they kind of go hand in hand. But if you feel you're confident and you're going to be okay, then okay.
Best of luck.
Yeah, that's kind of the answer to that.
Right.
This next one kind of addresses, it's similar to the last question, but I think it's a little bit different. Are we okay with having pay differences between part-time and full-time employees, i.e. part-time are ineligible for benefits, and we usually pay them less? That's a little different. It's not focusing solely on the benefit part.
The benefit part's the same answer to the last question that we just answered a second ago. As far as paying them less, I mean, if they're doing the same exact job, and you're paying them less just because they're not a full-time 40-hour-a-week employee, that could get dicey. Substantially similar work, I mean, you'd have to be able to justify that somehow a part-time employee's, work is dissimilar, and if it's the same job, I don't see how you can do that. Do you have any thoughts on that, Dina?
No, I mean, I agree. No, nothing else to add, but I agree with you 100%. Yep.
This next one is more for Anthony and I. We get our job applications from NJCAR. Will NJCAR change the application to remove salary history questions?
We will when the law changes.
Right, as they said before, right now this is for public.
Yeah.
For public,
an
not for private.
executive order that deals with the public sector.
Right.
The legislature passed a bill when Christie was still in office. I think he may have vetoed it or it didn't reach his desk, but if it hits Murphy's desk, he'll sign it. He'll sign anything.
Oh, he'll sign it, all right.
Yeah, and then once that happens, we'll change it. But, why change it now when we don't have to? Maybe you want to know that stuff. Get it while the getting's good. That's what they say.
All right, we're barreling through here. There's some good questions. We have base salaried sales personnel who receive a starting salary that differ within $100 dependent upon previous experience. What is your opinion on this practice, and should we stick to just one starting base salary for each or for all?
Seems like a negligible amount of money to really be, I don't know if it's going to make that much of a difference for an employee's decision to sign on. So to the extent that it's that small, I don't know if it's worth having the discrepancy to allow people to fight over it. If you're talking about more money in a more competitive position, like in the F&I department where you're competing for talent, maybe you need to have those differences to bag the employee that you want. So for an amount that small, it may not be worth the opening yourself up to a line of attack. I don't know, Dean, if you have any thoughts on that.
Yeah, no, I agree with that. For such a small pay differential, my thought would be to equalize it. And because if you do an audit or you're looking at it and you say, those that are receiving the higher amount just happen to be, workers who are Caucasian and, age X, and those who aren't receiving it are in this protected category, I may be vulnerable to an issue, right?
Yeah.
So to me, for such a such a small difference, I would say equalize it. Equalize it.
Can we at least ask but not require employees to not discuss compensation information?
I think it's 6 of one, half a dozen of the other. I mean, they're going to say that it was required, it was implied that it was not going to be tolerated. It just, you go to court with a situation like that, and yeah, you go down the rabbit hole with all the ways that they could claim that it was in effect required, not voluntary.
I agree. I think it's hands off. It's hands off. It's got to be tone deaf to it almost.
Absolutely.
They just can't do it. I think anything from management, not good. Yeah.
Don't ask, anyway.
Does the law extend to severance packages? Can you require that the terms of a severance never be disclosed?
Well, the hope is that when you get that severance package, you have a full waiver and release of all claims as part of it, and then you don't have to worry about them suing you. But I don't know, Dina, do you have any thoughts beyond that?
I mean, and then you also have confidentiality. So,
Right.
I think you have to consider separation agreements completely separate. Completely and totally separate here from this. Yes, separate.
Okay. You have an employee with several different responsibilities. You take certain responsibilities away from that employee. can you take away the compensation that was specific to that responsibility, which obviously results in a decrease in their overall gross wages?
I'd say who's gaining those responsibilities, and are they getting more pay? And then compare the different classes, protected classes of those employees, and you get your answer.
Yep.
I mean, it's very fact specific. It's hard to give an answer to the question.
Yep, I agree with that. And also the issue is, if you're decreasing their responsibilities, are you keeping them in the same job with the same job title, right? That's an issue there too. So if you're decreasing an employee's responsibilities and you want to take away their their benefits or to decrease their pay, you better be changing their job. Okay? Because you're going to have a problem. Yeah,
I mean, anything you take away, you got to ask yourself, well, now who's benefiting from this? And then you got to do a comparative analysis, and you just got to think. I hate to say this, but it kind of creates every little decision you make. You got to look at it from the angle of litigation, which is terrible. But unfortunately, that's what this law is doing. It's kind of driving itself into every little decision you make as to, employees' responsibilities and compensation. So, it's tough, but it is what it is, unfortunately.
Okay, we're going to keep barreling through here. For multiple owned dealerships, what is the litmus test for commonly owned?
I think control is a big part of it.
Yep.
I mean, I guess you look at the same test that you use for the wage and hour laws. I mean, common control. It doesn't really corporate structure in this realm is not necessarily relevant like it would be in a contract case. I mean, it's who's pulling the strings, and if that guy pulling the strings is putting forth a pay structure that is in violation of this pay equity law, I think they're not gonna draw a distinction between two separate corporate entities. If the common shareholder for both of those entities is John Doe, dealer principal, and he owns 99% of the shares of both, and his son owns the other 1%, I don't think it matters that the two dealerships are Corporation A and Corporation B.
Yeah, I mean, and if you have, the other thing is too, like if you have one person that's making the daily decisions that each multiple dealership has to report to,
right.
Centralized human resources. Again,
Yep.
That is what is considered common control.
Yep. Yeah,
Yep.
I mean, you're just drilling down deeper into the management structure, but yeah, if there's one office manager or general manager or controller or human resources department that's controlling multiple corporate entities, it's a no-brainer. You're going to end up getting ensnared in this thing if you don't have a consistent structure throughout.
Candidates will often skillfully avoid answering the request to provide salary requirements. Can you say only candidates supplying tangible salary requirements will be considered? That's an interesting question. I thought the same thing when they were mentioning that before.
Tina, you want to take a stab at this one?
Oh boy.
Most people don't want to be the first one to give a number. I understand where they're coming from. So can you turn that around and say, hey, I need to have an idea?
Well, I would say, what's your expectation? What would you like to get paid working here? I mean, I think that's the question. I'm reluctant to make the job contingent on having them. I mean, but like Anthony said, it's not illegal yet. I mean, it just, it isn't. But I would tread cautiously and instead say, in order for you to be hired here, I need to know what your salary demand is, right? What do you expect to be in? What is your salary requirement if you get this position?
I mean, there's nothing wrong with that. That's,
and there's nothing wrong with that.
An offer. That's, I mean, if they outlaw that, I don't know what we're going to do.
Right.
But I mean, really,
no, I agree.
You're trying to figure out, it's the labor market, still a market to this point, and in that market, there's employees and there's employers, and they negotiate, an offer and acceptance for a job. And so I think there's nothing wrong with what you just said. I think it's completely acceptable, and I don't know how else you would do it.
Okay. People are starting to drop off here, so let's try to hammer through these last bunch of questions.
Yeah, we're about 3 minutes away. Let's do this.
That's right. We can go. The questions are there. The questions are important, so we'll hold on. And I'm assuming people who ask them are holding on. So.
Yep. All right.
In NJCAR's experience, what do you feel the biggest threat may be? In what department and or position? Service reception, sales reception, full-time, part-time?
Well, I mean, it's tough for me to give you a one-size-fits-all answer because every dealership's different and every, dealership group's different. So I can't really answer that. I mean, you really just got to look inward to your dealership and be honest with yourself and just kind of take a sober approach to it and say, where are the pressure points here? But it's hard for me to give an across the board, viewpoint on this because every dealership's different. And this law just went into effect. I mean, they signed it on April 28th and it went into effect on July 1st. So, I mean, we don't have any real experience to base any type of analysis on. We haven't really been able to conduct a statistical analysis because there was no need to, and this came on really quick. So, I mean, ultimately, it's a dealer-to-dealer answer to that question. I wish I could be less lawyerly in my response, but unfortunately, it is what it is.
Yeah, and to everybody who's still on the call, like as Anthony said, some of this maybe you may have to call and ask him your specific situation. As you said, he can't do a blanket answer.
Right, and and this gets into the attorney-client privilege again. You got to be very careful. Who knows about this issue in your dealership and who's dealing with it? You don't want to have, as Dina said earlier, 9, 10 different people all working on this at once because every one of them's a witness. You want 1 or 2 people and a lawyer. And everybody at that law firm who works on your equal pay audit has that confidentiality provision in place. This can turn into a total nightmare if you wing it and then somebody sues you. All right. So I can't reiterate that enough.
This last one was addressed a little bit, I think. When you speak of comparing wage rate in all operations, including out-of-state facilities, does this just apply to a dealer group operating under one tax ID or all dealerships under common ownership? I think that was kind of addressed earlier. But.
Yeah, I think we already kind of hit this.
For the same position type and responsibilities, one person worked for 5 years and another for 11 months. Can we give a raise to one and not the other?
This is, again, very fact specific, and there's not really enough facts in the question to answer it effectively.
All right.
I mean, I think my advice would be what you're going to need to look at is, again, you're going to have to look at, because don't forget, you could have the person that's been in the job the shorter amount of time with a more qualified background in the industry. Right. So that's a factor. So you got to really think about the factor. You have to think about, is the person that, has worked there for the shorter amount of time, do they have more job responsibilities? Do they, and if you're going to do it, you better have it documented as to why, right? You better have those factors documented. But certainly longevity in the position cannot be the only reason. Can't be.
Right. This next question, that kind of dovetails into this next question. If you have multiple ATECs, do they all have to be at the same pay rate per hour? Would it be levels of experience?
Again, it's fact specific. I mean, what is an ATEC? What does it involve as far as that category? And then between the ATECs, how much experience do they have? How much education do they have? How long have they been at the dealership? Do they have any specific credentials related to their position? You go down the rabbit hole, and that's why we strongly recommended these pay equity audits, because there's so many facts that you're going to need to mine to figure out the answers to these questions, and you need an attorney to do it. So if you ever get sued, it's not fair game for the lawyers. We've got a few. I'm going to just note, we're actually recommending, getting a firm like Genova Burns, who has a program in place to do this. There's a flat fee program that they're rolling out to do this pay equity audit, the first phase of it, to really kind of find the pressure points for you. And then from there, you have the attorney-client privilege in place. You decide where you want to take it. We highly recommend that our members get on board with a program like this, because like I said before, you do it yourself, you're setting yourself up for disaster. You heard Dina go through all the horrors if you were ever to be found liable under this law. If you're doing this in-house and you got 10 people working on it, they're all witnesses. They may all say inconsistent things when they're deposed, or they go to get on the witness stand, and then you got problems. You get a lawyer to do it. You got 1 or 2 people in upper management who work with the lawyer. It's all privilege you're in the driver's seat, not the plaintiff's lawyer. So I can't stress that enough. When you get into these fact-specific questions, I mean, you're driving yourself to the audit. You're just telling me that you may need an audit here.
If any of these questions are that way, just tell me that, because that way we can hammer.
All right, let's do it.
For commission-based employees, are we okay as long as we are providing the same potential to earn? As long as we're not offering higher commission percentages to individuals, it doesn't matter that two salespeople are making significantly different amounts annually. That's
right.
However, somebody sells more cars, they're going to make more money.
Yeah, I think that would be they'd be hard pressed to argue that the exact percentage commission amount for two employees and one sells more cars than the other, unless the employee could argue that they were somehow put in a position in the dealership and location in the dealership where they couldn't sell as much because they were a different race. I mean, they weren't there peak hours when the most traffic was coming through the dealership. I mean, unless somebody could claim that, simple percentage and different amounts in and of itself isn't going to be a problem. But again, you got to drill into it. I think, and honestly ask yourself as an employer, does employee A, does he have a better, position on the showroom floor to sell than employee B? Or the F&I guy, is he in a better time slot to make the big bucks than employee, B? And are there different races or different religions that could be pointed to as a basis for disparity? I mean, again, it's fact specific.
Exactly. But I agree. On paper, right, the commission structure is the same for everyone. But like I said, Anthony, all the things that Anthony just mentioned will certainly be looked at. Because in terms of the same, quote, opportunities, right, that's the question. That's a question posed by, one of our members, and also a question that's going to be posed by a court, an arbitrator, whomever. Was it really the same opportunity for business? That's going to be the factor.
Okay.
Go ahead.
Please provide a legal definition of affectional orientation.
That's all you, Dina.
I don't know if I said that right.
Oh boy, I know. What is affectional orientation? Well, maybe they don't. How can I explain? They don't identify. Affectional is also romantic orientation, right? So I know it's very weird. It's it indicates the sex or gender with which a person is most likely to have a romantic relationship. So it's more like their romantic orientation, that they're more likely to have a romantic relationship with a man or a woman. That's really what it means. Okay. So much like sexual orientation.
Can you fire people for not signing an arbitration agreement?
Let's put it this way. Legally, in and of itself, you could, to the extent that they're at will, but when you fire somebody for an arbitrary reason like this, you're asking for trouble. It's better to do it in a way, like I suggested earlier, as part of a bonus to get them to sign it, as part of a raise. So they're focused on the positive than to have a negative, kind of connotation with the agreement. You sign this or I'll fire you. Then you're going to have a problem. So
you can certainly, and you can certainly condition it on hiring. If you don't sign the arbitration agreement, you're not hired.
The next question actually expands on that. Arbitration agreement. Can you have active employees sign them, or only going forward with new hires? What if they refuse? I guess, what if the active employees refuse?
We've already kind of went into this. I mean, you need consideration. You need consideration. So if the status quo exists and you just want them to sign this thing, there's no thing for a thing, there's no bargaining involved. The court may be loath to enforce it. However, if you have some type of financial incentive, like a bonus or a raise that's accompanied with them signing a bunch of paperwork, quote unquote, and you throw this in there, you're more likely not only to have it be enforceable, but you may never even be challenged or even known about by the employee. So I mean, look, technically, you could probably make a technical legal argument for firing somebody for not signing an arbitration agreement that's put in front of them, but you're going to end up in a situation where they're going to sue you, and the lawyer is going to be creative and come up with some reason why it wasn't the arbitration agreement, it was something else. I wouldn't go there. I would just have it condition upon hire, and then try to, at year-end bonus time, have them sign a whole bunch of new stuff and have a separate arbitration agreement as part of that bunch of new stuff.
Right.
All right.
Would you agree, Dina?
Yep, agreed.
Okay. We're coming down to the last 10 or so. We had a lot of questions. Could lead distribution be brought up when discussing sales commission income differences? I guess how the leads are distributed.
Sure, absolutely.
Yep.
Okay. Next one. If we have to hire someone outside of the normal salary range due to just having difficulty finding someone, say we have to hire for $3 an hour more than normal, how long can we wait before we have to give current employees raises to meet this hire? Or is it okay if the rest of the comparable staff are not protected employee classes?
Yeah, it's sad when you read these questions and it just becomes evident to you just how half-baked this law was, but I mean, ultimately, I don't see how you can't, as insane as that sounds.
The question is, I mean, I think the answer is, as soon as you find out.
Right. And it's ridiculous because,
as soon as possible.
Right.
Can signing the arbitration agreement be a condition of continued employment or for employment for new hires?
We already went through that, yep.
Yeah. Lots of questions on the arbitration agreement. Good.
Is covering a greater percentage of health benefits based on tenure an issue?
Covering greaher percentage of health benefits based on tenure an issue? Yeah, I think so. I mean, ultimately, it's a pay difference based on age. I think they could claim it's a pay difference based on age because the longer you've been there, the more you get. I mean, again, there's a completely legitimate, business reason for doing that. Employee loyalty, garners you more compensation. But, somebody on the receiving end of that, employee who hasn't been there that long, who's got a health condition, may say, you know what, I'm going to sue and make this an age discrimination issue. And then you're dealing with a lawsuit. So again, as much as it's, as I said before, you start getting into the weeds with this law and you realize just how insane it is. But I can't say that this wouldn't be an issue. Do you have any thoughts on that?
No. I mean, I agree because I think you may have a disparate impact issue based on age. So you may have to look at it. Now, you may look at it and say, well, wait a minute. Now that when I do my analysis, there is no disparate impact here based on age because it affects people under 40, over 40, men, women, whatever it is. And so maybe actually when you do your analysis, there is no disparate impact, but there might be. And if there is one, then you're going to be second guessed.
Yep, I'm with you.
Okay. If I have multiple dealerships, one with a collective bargaining agreement, the other without, do I then need to match the higher pay for the same position?
Oh, God.
I'm gonna argue no with a CBA and a non-CBA, but I don't know. I have to get back to that person. That's an interesting, unless you have a thought, Anthony, but I got to think about that.
I mean, I think my guess is your instinct as to why it would be no would be that, bargain employees are just a totally different class of employees. You can use that as a legitimate business justification for distinguishing. They're represented. But again, I feel you that it's tough to get to an answer on it because, I could just see a court being like, well, they get the benefit of the other employee's bargain. As nuts as that sounds, we're in New Jersey. I mean, anything's possible.
Yeah.
You think that's? You think I don't give our state enough credit with that dreary analysis?
No, you do.
The person who asked that question, I would recommend calling either Anthony directly.
Yeah. Let's talk about that.
Handle out. Is there a benchmarking company for automotive dealership wages, salaries in New Jersey?
There's not a company that does it. I know the NADA releases an annual report about wage and compensation trends in the industry. They sell it on their website. It's actually extremely useful. A lot of our members,
very detailed.
Yeah, it's extremely detailed, extremely useful. It gets into regions over the country and different pay for different types of positions within the dealership.
And actually, for that,
I like that.
If you participate in it, you don't get everything, but you get quite a bit as a participant,
right,
for free. If you don't participate, then like Anthony said, they do charge because they spent a lot of money on this report.
It's extremely valuable, though. I mean, I really can't recommend. If you're as part of this whole pay equity audit process, obtaining a copy of that and giving it to your attorneys, as a reference point, would be very helpful for them. So to the extent that you're thinking about doing the right thing here and signing up with a law firm to do this for you, get a copy of that before you go in and meet with them and say, this is what I have as far as the kind of the structure across the board, and you can use this as a reference point. It's good in court too, because if your attorneys are using that, there was some statistical analysis done there by the NADA, it gives you some kind of sheen of legitimacy to what you're doing.
Right. No, that's great. That's a great tip.
We're down to the last couple here. A few people did ask, will a copy of today's presentation be available? We will be putting a recording of this webinar as well as the slides online, and we'll send all the participants a direct link to that recording and the slides. Ask that you not share it widely. This seminar was targeted to certain positions, and we want to try to keep it to that if we can. But you will, and all the participants or registrants, if you didn't sign on today, will be getting a link to that. So there's a couple more actual questions. One of the examples you used was a receptionist that has been employed 5 years versus a new hire and the pay difference. You mentioned changing the title to senior to get around this new law, but the tasks between the two are identical. How would that work?
That's right. Tough, right?
They would need responsibility.
Yeah, well, the responsibility also, and the qualifications for the senior receptionist would have to be differentiated between the qualifications needed for like the entry-level receptionist, right? So we'd have to change, so that job description for the senior receptionist would have to maybe include, more experience or a college degree or something else that would differentiate it from the entry-level receptionist position. Because you're right, if they have the same job duties, we're going to have other differentials to point to when we create the separate job title.
Yeah. Again, this is the theme I think that's emerging here through all these questions. It becomes extremely fact-specific for every dealership, for every employee, comparing one employee to the other employee, apples to apples, apples to oranges, figuring out what's what. You really got to drill into the weeds with your particular dealership. And again, I can't stress it enough. Do it on your own and to your own peril.
Last few questions.
Okay.
If we have employees, managers who do not pay for health insurance, can that become a problem? I think we already addressed that.
Yes, we did.
Yeah, I think we did. It's in effect, yeah.
It's covering more benefits based on job description title. Would that be okay, as long as all the titles receive the same amount of coverage?
I think that's kind of the same as the last question.
I think that's it.
Okay.
Looks like that's it. So
I see a final little sentiment here from a dealer principal about kind of keeping this information kind of under lock and key at your dealership. I mean, this is like the envelope in Mission Impossible. Do not, share this with many people at your dealership. I mean, one or two people should be privy to this, the dealer principal and maybe an office manager or a controller, and the two of them should sit with a lawyer who knows what they're doing with this stuff and come up with a game plan. It shouldn't be like, let's get a big meeting together of 15 different people and riff about this for an hour, because everybody in that room in that meeting is going to be thinking, well, wait a second, what about me? So you really have to keep this under lock and key until you get a lawyer in the mix and start figuring out how you're going to handle it. This is not something you want to make it a big, kumbaya moment at the dealership where everybody gets together and they try to figure it out together, because that's going to end in tears.
Exactly. Need to know only.
Yep.
Well, let me thank Dina.
Yeah, Dina, thank you
very much. Thank you, Anthony.
Thank you, guys. Thanks, everybody.
We hope everyone found today's webinar informative and worthwhile. Sorry if we scared the hell out of you. If you have any additional questions, definitely encourage you to contact Anthony. His number here is 609-883-5056. extension 350. You can contact Dina at Genova Burns. 973-533-0777 is the main number. Do you have a direct line you want to share with Dina? Or
Oh, yeah, 973-535-7117. It's on the last slide, too, if anybody needs it, along with my email address.
Okay, and as I said, we will be sharing a copy of the recording and the slides to the people who were invited to participate in this webinar.
Please do not share them, and it's just incumbent that you keep this stuff close to the vest until you get a game plan in order with your lawyers.
And I encourage, finally, I encourage everyone to regularly check the NJ Carr Academy webpage on our website for a complete list of all upcoming live and online training opportunities. Thank you again, and this concludes our webinar.
Thank you.
Thank you.
Thanks, everyone.